Members, we move to House File 905, our bill of the day, I believe this is going to be. And members, we will be laying this bill over, so we have now until 10 o'clock unless we want to come back tonight after House session. So I think we can accomplish this. The chair will move Representative Kresha's 905 to be before the committee. I don't believe yes, there will be an amendment later when we get to amendments. Representative Bly has one, but we'll deal with that after we've had an explanation of the bill. Representative Kresha, please reintroduce yourself and explain 905.
Thank you, Madam Chair. And so if you've heard as much about this bill as I have, I've heard from both sides. And I want to be very, very clear about what the intention I have in bringing this bill forward. I'm just looking for a conversation. We have conversations all the time. What we have is a committee process. I'm going to tell you I actually don't know which way I am on the language of this. But what I do know is we need to bring groups to the table to have the conversation so that one group doesn't feel like the language that's being introduced is being pushed at them or shoved to them unfairly. So what I'm doing with this bill is, and I'm sure we're going to have lots of testimony, we're going to have, I'm hoping, not a lot of passion and anger on either side. What I'm hoping we can do is have the conversation so we can get to a respectful place and come back with a compromise that actually solves this problem. Because the reality is you're going to hear from both sides that have very, very strong and legitimate arguments, and let's hear those, and let's see if we can do what we're supposed to do down here, which is come up with good policy. So with that, I'm actually not going to say a lot about it. I'm going to open up the court and let the testifiers make their cases.
And members and those who are testifying, we're going to allow 10 minutes for those who support and then 10 minutes for those who have concerns. So you'll have to make sure that your comments are not repetitive to fit into that time slot. And if we can exceed that a little bit, because we are right on time, according to the schedule we set out, we'll provide for that. So we'll start with those who support. Welcome to our committee. Please say your name for the record and begin.
Good morning, Madam Chair and members. It is an honor to appear before you. My name is Michael Waldsberger, and I am an attorney with the law firm of Rupp, Anderson, Squires, and Waldsberger. In fact, I'm one of the founding partners. My firm represents nearly 1/2 of the public school districts in the state of Minnesota, as well as many charter schools. I've been practicing law since 1994, and more than 20 of those years have been dedicated to the practice of school law in Minnesota and Wisconsin. And I'm testifying in support of a proposed amendment to eliminate the word willful from the Minnesota Pupil Fair Dismissal Act. Expulsions have never been easy decisions. School boards agonize over the right course of action, over balancing the rights of students, all students, and the right to safety and to an education, and the interest of a student who's been proposed for expulsion, and I've observed that firsthand. By way of background, the Minnesota Pupil Fair Dismissal Act has 3 grounds for dismissal. 1, willful violation of any reasonable school board regulation, provided that the regulation is clear and definite, and notice of the regulation is provided to pupils. 2, willful conduct that significantly disrupts the rights of others to an education, or the ability of school personnel to perform their duties or school-sponsored activities. Or 3, the third ground is willful conduct that endangers the pupil or other pupils or surrounding persons or property of the school. For more than 2 decades, the language willful violation or willful conduct, and let's talk about the willful violation of school board regulations first. That was interpreted to mean that a student had received notice of a regulation and then engaged in conduct that violated the regulation. So for example, if you had a school board regulation that prohibited the possession of illegal drugs at school, and a student was aware of that regulation, was given a copy of it, was reviewed with the child, and the student subsequently was found in possession of marijuana at school, that student would be deemed to have willfully violated that regulation. Similarly, with respect to the ground for dismissal for willful conduct that significantly disrupts the rights of others to an education, that meant that the student willingly or knowingly engaged in conduct, and it had that effect of disrupting the rights of others to an education. As many of you know, on August 3 of 2016, the Minnesota Supreme Court issued a decision in the matter of expulsion of AD from United South Central Schools. The court held that the Pupil Fair Dismissal Act requires a school district to show not only that the student knew of a school policy, but also that the student made a deliberate, intentional decision to violate that policy before the student can be dismissed, meaning suspended, expelled, or excluded. That second requirement is brand new. The facts in the United South Central case are very instructive, and I think you need to know about them. In short, in that case, there is no dispute that the student knew of the district's weapons policy. Also, there's no dispute that there was a knife found in the student's purse in her school locker. However, the student claimed in that case that she had totally forgotten about the knife found in her purse, despite the fact that she brought the same purse to school on the previous day, and despite the fact that she remembered when the school was in the middle of doing a school-wide search, whoops, I have a knife in my purse, and she doesn't tell anybody. The Supreme Court said because she forgot, or she claimed she forgot, there was not willful conduct there, or willful violation of the statute. The court also held that possession of a knife by itself doesn't automatically endanger others in a school environment. Now, what's the practical effect? What I really need Madam Chair, you and the committee members to know about is that as a result of that decision, in literally every single case involving possession that our office has seen since the United South Central case, the student has asserted, "I forgot." It's a very hard defense to overcome. The reality is it doesn't take students long to learn the value of the "I forgot" defense as soon as they get an attorney to represent them. And if the law doesn't change, we're going to certainly see that defense asserted in every case. The other big concern that I have is that school districts are now unwilling to even consider expulsion because the burden of proof is so high, because the playing field is now slanted so far in favor of students, and it adds to the expense of the process as well. In my personal observations in my practice, again, representing roughly half the districts in the state, we've seen roughly a 10-fold decrease in the number of expulsions coming forward. This doesn't mean that students aren't engaging in that same serious, concerning, dangerous behavior. It just means that expulsion is not happening. And while on the one hand you might say that's a positive outcome, the reality is we have students who are presenting a risk of harm to others and are still in the school environment. I'd like to just take one moment to debunk a couple of myths that you may hear about. One, you may hear claims that removing the word willful will have an adverse impact on students with disabilities. Such claims are simply untrue. Students with disabilities have significant protections under federal and state law. They cannot be expelled or removed for behavior that's a manifestation of their disability. Plus, they have the right to have their IEP implemented during the period of expulsion. All students, in fact, have a right to receive educational services during a period of expulsion. The same is true for students of color. The law prohibits any kind of discrimination based upon race, color, religion, or other protected class status. And then finally, any kind of parade of horribles that you might hear about is really disproven by the fact that we have 20+ years of history. In short, statements of fear about removing willful are not based in fact, because removing willful will do nothing more than return the statute to the way it was interpreted for more than 2 decades before the Supreme Court's decision in United South Central. And with that, I'd like to say thank you and turn the time to other people in support of the bill.
Thank you, Mr. Waldsberger. We have a few others, so if you have something different to say, please say your name and begin.
My name is Paul Schmitz. I'm the principal at Wilmer Senior High School. Madam Chair, thank you for the ability to talk on this issue. I'm not an expert. I'm bringing my opinion from my small rural district. My district is, I've been in education for 25 years. I've been in an administrative role for 16. During those 16 years, I've overseen programs that I was responsible for the discipline policies in level 3, 1, 2, and 3 emotional and behavior disorder programs, in our alternative learning programs, and now at the Wilmer Senior High School. My district has rising poverty. We're up to 70% in some of the buildings, and we're over 50% in all buildings. In that time, we have dropped the days lost by suspension by 300% in the last 7 years in my building. So equal access to education and due process is a passion of mine. I volunteered to be on the Pupil Fair Dismissal Working Group that was that was in statute by the legislature and presented at the House at this committee last week. I've been part of spirited conversations. I think there is right for people to be concerned about due process and access of education for students. However, I don't believe that this particular portion of the bill reaches that. I think the use of the term willful will put us in an unknown position, and we can spend all sorts of time talking about potential unknowns. If a student brings prescription opioids to school, do we have to prove that they knew that they were class 2 in order to have a discipline? If they say, I didn't know what they were as they're distributing. I think this will put administrators in litigious situations, and I think there's enough unknowns with where this will go that it concerns me, even though access to education is one of the most important things to me in my career. And the one thing that I will repeat is the exclusion of the word willful will keep us status quo. That now, because of the Supreme Court rule, the new definition of willful, that will put us into the unknown. So I'm asking that you keep it the way that it is and address access to education and due process through measures that you've seen through other bills, especially from the committee that I was a part of. Thank you.
And we have another testifier. Very quickly, if you have something different to say, please introduce yourself and begin.
Madam Chair, committee members, my name is Greg Cole. I'm a district principal and district administrator for the Anoka-Hennepin School District. What I will say is two things that we celebrate, and I believe that the other districts in the state of Minnesota celebrate these two things. One is when our families, our students, and our staff report they feel safe in our schools, that their kids feel safe in our schools. In the mid-90s, our survey data show recently, we celebrate that. The other thing that we celebrate as much as that is when our suspension or expulsions go down. If they go up, if we have more suspensions, that is a disappointment, that is a failure, that is something that we look at and say that we need to do better at. And so just please know that when we're talking about removing willful, that is not a way that we can find ourselves suspending more kids or expelling more kids, because we would view those things as failures, and I believe that our colleagues in districts all across Minnesota view it the exact same way. Thank you.
Thank you, Mr. Call. Very quickly, sir, say your name and begin.
Madam Chair, members of the committee, thank you. My name is Peter Shaw, and I'm the Assistant School District Attorney for the Rosemont Apple Valley Egan School District. And I will be very brief. Just like to say that first and foremost, District 196 wants to keep students in the classroom, and we support alternatives to suspensions and expulsions, and we're very happy that in the last 5 years there's been a downward trend in suspensions and expulsions in District 196. But what I'm concerned about is the standard placed on school districts to prove a willful violation as interpreted by the Minnesota Supreme Court. And Mr. Waldsberger really explained this well. I'll just emphasize that the standard that the Supreme Court is holding school districts now to prove a willful violation is in fact higher than you would see a criminal prosecutor have to prove in a criminal case, where simply the prosecutor would have to show that the the defendant, did a bad act, that they intended to do the bad act. Now school districts are held to the higher standard of having to show that the student deliberately made the choice to violate a school policy that they knew about. So I support passage of House File 9005. I believe it still obviously keeps substantial due process rights for students, and it adds some for elementary school students. And with that, I'll yield. Thank you very much.
Thank you, Mr. Shaw. And I know there are those in the audience who have come. We probably don't have time to hear from you, but if you are a school official, would you please stand so that we know that we have many in the audience who are concerned? Thank you very much for coming. And please don't leave, because when we get to question time, we'll need you to answer questions if they arise. Now we'd like to turn to those with concerns, and you will have a little extra time. You'll have 1.5 minutes extra, so I think we have John Thompson, Kalia Pringle, Melissa Gallagher, any of you want to come forward, please, and share with us probably something different from each of you in regard to your opposition to this change. Welcome, say your name for the record and begin.
Madam Chair, members of the committee, my name is Andrea Jepson, and I'm going first because the group of us that are here in opposition to House File 905 have decided that it makes sense to have me come first, because I am the attorney who argued the INRI AD case to the Court of Appeals and the Minnesota Supreme Court. And the INRI AD case involved a student who accidentally brought a small pocket knife that she had been using to bale hay on a friend's farm. And in August of 2016, the Supreme Court affirmed the Court of Appeals decision that when the legislature passed the Pupil Fair Dismissal Act in 1974, it intended the word willful to have its plain meaning, which is intentional. So when you're told the Supreme Court created new law or altered practice, it's important for you to know that the Supreme Court and the Court of Appeals opened a dictionary and didn't change the law, but rather made clear that school districts who were not following that standard already were not following the law. But I didn't need the Supreme Court to tell me that the legislature intended willful to have its plain meaning, because I spoke to Senator Joe O'Neill, who sat on the Senate Education Committee in 1973 and 1974 and heard one of the bills that would ultimately become the Pupil Fair Dismissal Act. And I asked him, Joe, in 1974, did the legislature intend for willful to mean anything other than intentional? And he was emphatic that it did not. But I also understood the legislature's intention because I spent a week at the Minnesota History Center reviewing the legislative history of the Pupil Fair Dismissal Act. And what I learned was that it was an act that was passed in response to significant litigation around the due process rights of children in school, and that it had broad support from school districts, school administrators, teachers, community members, and students, because this students' right legislation, they believed, would stem the flow of litigation. I caution you to, when you hear, I think it is fair to say that school districts want to avoid expelling and suspending their students, but I caution you to look at the data, because expulsions and suspensions are on the rise. For the last year that we have data, that's 2015, 2016, our state suspended and expelled 54,000, almost 55,000 students in our state. That information is available on the Department of Education website. The year before that, we expelled and suspended 40,000. The year before that, we expelled or suspended 50,000. Our suspensions and expulsions are on the rise. But the most important thing I can tell you as a lawyer today is, first of all, you should take legal arguments with a grain of salt, because lawyers will disagree about the status of the law and the implications under the law. But what I'm here to tell you is that if the legislature turns the Pupil Fair Dismissal Act into one of these so-called zero-tolerance policies, which is almost universally frowned upon as a best practice by all kinds of national organizations, including the NEA, the National Association of School Social Workers, the National Association of School Psychologists, it will create an unconstitutional statute. And that's a big problem, because people are going to start lining outside of the door at my office and other attorneys bringing suit again. And that's because the Minnesota Constitution created a fundamental right in education for our students. And when you have a fundamental right, you have certain protections provided to you under the state constitution, but also under the US Constitution. And one of those rights is the right to due process. Due process means there are certain kinds of procedures that need to be followed, but due process also means that you have to have notice so that you can order your behavior according to the expectations of a rule. And you can't order your behavior if you can be suspended or expelled for behavior that is inadvertent and accidental. That's what we're talking about here. Inadvertent and accidental violations of rules could result in a loss of education. When I was at the Court of Appeals and the Minnesota State Supreme Court, I urged the judges to remember that showing willfulness is not an impossible burden. Mr. Waldsberger was not correct in telling you that school districts have a high burden in a school dismissal in case. In fact, the burden is very low. All a school district must show is that it's ever so slightly more likely than not that the student engaged in willful conduct or a willful violation. And that student doesn't have to say, I intended to do it, which has been an argument. Rather, schools are free to look at the totality of the circumstances. Was a kid carrying a knife in their backpack? Well, you don't bring a backpack anywhere other than school. That gives schools a pretty good idea that this is willful. Did a student have a small knife in her purse and a history of working on a farm? Well, then it probably was unintentional. Just ever so slightly more than not. There's a terrific amount of discretion in that. It's very important also for this committee, the legislature at large, and school districts and the community to remember that we're talking about the loss of a child's education. I know that many people will come after me and tell you that suspension and expulsion, well, maybe they won't, let's hope they won't come in and repeat this, is the data show us that, that suspension and expulsion are correlated to an increased risk of repeating a grade, an increased risk of not graduating from school, and an increased risk of future contact with the juvenile and criminal justice systems. And there are other ways to correct a child's behavior. Schools have almost unlimited control over their ability to punish students creatively in ways that instruct and don't exclude and don't interfere with students' education. This is a statute about the circumstances under which a child's education can be taken away. And if this body ultimately takes away the willful standard, we're going to have a very serious constitutional issue. Thank you.
Thank you, Ms. Jepson. Committee, this is so interesting, isn't it, that we get to hear two sides of a very critical issue. It's just amazing to me that we have this kind of talent out there who can come to us and help us understand these issues. I think, I don't know who we want to hear from next, but will you say your name for the record? I believe
Melissa
you want to.
Gallagher.
Yes, and please speak.
All right, thank you. I'm here for the student of education reform. I don't agree with this bill. How can a child get an education when they get suspended or dismissed all the time for the littlest things? Teachers need to go into, I feel, an in-service, how to deal with children with ADHD, which my son is. Also, if a teacher has it out for a child, then that child's doomed. Also, what are the consequences on a teacher? Sexual harassing, bullying, cursing at a student. I just wanted to add, like I said, my son is ADHD. He was dismissed over 100 times for being late, not having a pencil, getting up to go to the bathroom, which a teacher told him not to, and I told him to. Also, he got suspended and dismissed. Also, I have taught my children to earn respect, you need to give respect. And the teachers at Humboldt, including the principal, have always harassed my son. The only teacher that went above and beyond her teaching was this teacher named Teresa Banky. And I feel like don't pass the HF 905 rule. Thank you.
Thank you, Ms. Gallagher. Please say your name for the record and begin.
Hi, my name is Asia, and I'm with Students for Education Reform, and also a recent graduate at high school for recording art, a charter school. So me growing up into St. Paul and traditional public schools, I've constantly, when I say constantly, get suspended for willfully defining, for being late, for not having my pencil, or even for me having a bladder. So it really hurts. And then for people like lawyers or people that have not been around, like urban, and that's the people who is getting suspended, people of color, Latinos and African American, there's data out there. And then we have people, policymakers that don't be around or don't even know. And I feel like we should not pass this bill because we already got no tolerance law, and that is really bad, and we're adding more laws to put, you know, like we have like this standards of how a child's supposed to act or how a person's supposed to act, when we all know that we are not perfect, especially when we're going through adolescence. So putting these laws in here is because we don't come in on time, or because we accidentally brought a knife, or whatever the case may be, because of a farmer or whatever case, because of that fear that you have of our color. And that's what it is, fear. And that's what I'm going to keep saying, is that fear. So please do not pass this bill, because we got people from Anoka and suburban areas. Sorry. We got people.
Okay.
No. Yeah, no, I'm sorry. We just got people from different areas that it's not part of the urban area, just like we have teachers coming from suburban areas, coming in urban areas that don't, they have their certain way of how they want to have their classroom, and they're constantly suspending kids or expelling them.
Thank you. There's a principal in the audience, a Robin Francis. Could we hear from you? Sir, could you just wait until we hear from the principal? Thank you.
I appreciate it.
Welcome to our committee, and please say your name for the record and begin.
Thank you. I'm Robin Francis, and I'm currently an interim principal at Sankofa Underground North Academy in North Minneapolis. Again, I appreciate the opportunity to speak, and I'll be very brief. As a current administrator, I'm more than aware of our current discipline disparities. I'm also aware of the different districts that are currently under both a voluntary and involuntary agreement with the Office of Civil Rights. And the premise for these agreements are more than likely inequitable discipline practice. Taking away due process for students would be a step backwards. We need to be mindful that we're working with children, and they are going to make mistakes. And we need to put equitable practices in place that ensure our students learn and grow. As a leader, all of my decisions are made based on this mantra: what is in the best interest of my babies, my students, my scholars? And I have to ask you this: is this bill truly in the best interest of our scholars?
Thank you, Principal. We have one last testifier here. You know, those who won't get to speak today, we're going to have other bills coming before this committee, I'm sure, very shortly, and you'll be welcomed back to hear other proposals that will come forward. So please don't feel bad that you don't get to speak, but we have to have time for members to ask questions. Welcome, sir. Please say your name for the record and begin.
My name is John Thompson, for the record. I work for St. Paul Public Schools. I'm a machinist for the district. I'm quite sure you guys seen me before. My friend Philando Castile was the guy who was tragically murdered in St. Anthony. Me and Philando both work for St. Paul Public Schools. You're probably going to see me again. I don't agree with the bill, and it's simply because I want to bring truth to the matter. It's going to affect African American kids in the door. African American kids are the ones who are always suspended at an all-time high rate. And I want to coattail off of what the young lady said. When I come and see these bills, I always see our community underrepresented. Like, there's nobody from St. Paul that's here saying, yes, we support this bill. St. Paul's predominantly African American kids. You're going to put kids out of school for being kids and take the word willful out. Well, you willfully put them in the streets where they're willfully getting killed for stepping on another man's Jordans. We're talking about the kids 16, 17, and 18 years old. Also, if you want to do something, invest some money in parks and recs. You're going to put them out of school. Where are you going to send them? Where are they going to go? All right, this is going to affect African American children, and let me be clear: it's only going to affect African American children. I don't see many kids in Apple Valley being suspended. I don't see many kids of my color in Rosemont, but I do see it happening here in St. Paul. You guys have to get it right and stop coming for our babies. Stop coming for our babies, and that's what this bill is aimed at, our babies, African-American men, ADHD. Let me just give you a brief rundown about the African-American community. ADHD in the African-American household stands for ain't no daddy at home syndrome, all right? So let's get to the root of the problem, all right? Stop trying to substitute doing your job. Your job is to educate the kids. Your job is, once you get them in the building, to keep them in the building. Your job is to make sure that graduation is the key and not suspension. That's your job as an educator. We talking about lawyers. Lawyers are coming here proposing bills talking about kids bringing knives to school. Kids are being kids in these schools. I also see a large police presence in the schools. You want to stop some of this stuff in the schools. Stop spending all this money with the police department and start putting some of these parents in the schools on the payroll. I know I was, wait a minute, I know I was terrified when my mother worked at the school. My mother worked at the school, so I was terrified of the butt whooping I was going to get when I got home if I acted up at school, all right? So, I mean, you already made that, they already made that a crime, to spank your kid at home, all right? So, I mean, you're taking away all the tools that we use to educate our kids and to discipline our kids, and kicking them out of school is a cop-out. We need graduations and not suspensions. We need graduations and not suspensions. I'll say it 3 times. We need graduations, not suspensions, not expulsions. We need graduations. Thank you.
Thank you. And you know, everyone, keep in mind that we hear these bills so we can hear from you. And then we'll proceed to debate this. So we appreciate all the comments that you make. Whether we agree or disagree with them, we want to hear. We are the people's place, and so we really do appreciate. Members, questions for the author? Representative May Quaid.
Thank you, Madam Chair. Representative Kresha, I think there were some good points brought up, and so I'll ask you a question I've asked you before. Did you do an equity impact statement on this bill?
Representative Kresha.
Thank you, Madam Chair. And I've looked into that. That's done usually in law enforcement, not education.
Representative May Quaid.
Thank you, Madam Chair. That's correct. We actually only look at the impacts on racial disparities if we're talking about criminal justice, which I think is awful because there's a lot more things that affect people of color than going to jail. So you asked before all of the people who are here to support this bill. Can you guys raise your hands again? No, to support the bill. You raise your hand. Okay. To support the bill. Okay. Do you see that? Who doesn't support the bill? This is your equity impact statement right here in a room. You had 15 white guys raise their hands because they're here for this bill. And you have students of color, you have people of color telling you here that students of color get suspended more often. When black students speak differently than their white teachers, it's seen as being uppity, talking back, not being precocious or questioning. This happens every day. We have 96% of our teachers are white teachers, and we have a third of the students in our district, 196, are students of color. So I want you to think about these things. I want you to think about these things before you bring these bills to this committee. Think about the equity impact that we're having, because we have them in more than just criminal justice. We have to do better for our communities, for our state, for the people in this state. We have to have policies that take this into consideration. We don't want to debate that. We don't want to make people come and tell us what the equity impact statement is. Bring bills with that on it, because we keep perpetuating the racial disparities in the state, and we are doing nothing to check and see if the new things that we're proposing are going to help or hurt. So I think we've heard some of that today, but I really would ask you to continue to think about it and bring that here too. Thank you.
And Representative May Quaid, you can prepare a bill. You know that. And I know that there are others out there who are doing likewise. Representative Kresha.
Yes, thank you, Madam Chair. And if I could respond?
Yes, please.
I think if you look at the bills that I've sponsored, I'm right there. You can cast me however you want, but I'm the guy that crosses party lines all the time and is as inconsistent as you can be around here. I've sponsored bills that we need to bring more teachers of color in to match their students. I've sponsored bills. I have a bill right now that I'm listening to the groups in the minority community that are saying, we want choices. We want to get out of our neighborhoods. I've been the biggest advocate in child protection for the kids that are being in the most disadvantaged areas. So you can try to cast me however you want, but look at my record. I didn't bring this bill here and my initial comments were, I haven't told you where I am yet. What I've said is they need a seat at the table and they need a seat at the table. And what I'm asking you to do is to think about the conversation we have to have. You're absolutely right. But don't paint us into a corner when we bring a bill up. Let me give you some other examples, because I too have been a teacher. I've been in the middle of 18 and 16-year-olds fighting. I've been in the middle of those fights. I've had to break those up. I've had to back teachers. I've had to back students. I've been the one that has gone to the school board and said, don't suspend this kid. I've done that. I've also been the track coach for ADH kids that had nowhere else to go, and when they were swearing and using the Effenheimer at teachers because they didn't know any better because their meds had wore off, I was the one defending that kid. And what I'm saying to you today, community members, is let us have this conversation. Bring these two sides to the table and let them have the conversation. What I'm not saying today is make any changes. This bill will be laid over. What I'm saying is these groups have simply asked to have a conversation. Let's let that happen. Let's let the process, and I will give you my word, and my word is everything around here, that if I can't get compromised language from these sides, I will not come back to you with changes for this bill. But don't shut the door on them. Don't cast us as who we may or who you may think we are. I'm just trying to have the conversation. That's an opportunity, and that's all I'm asking for, Madam Chair.
Thank you, Representative Kresha. Representative Bly, you have an amendment to offer. Would you like to offer it?
Just to make some comments.
Please, go ahead.
And
so I think I'll say then that Representative Bly withdraws his amendment but would like to comment. Please go ahead, Representative Bly.
Thank you. And Representative Kresha, I was very heartened by your opening statement. I think you're absolutely right. This is a conversation that needs to happen, which is also why I feel very comfortable withdrawing the amendment, because I believe that that conversation will take place. The testimony on both sides was very good and informative, and it's great that we've started that conversation. I just want to say two things, I guess, and one is that, and I take these as symptoms of why we're here. And one is that I think it speaks to our lack of understanding of behavior and how to deal with behavior. And that's something we need to confront as educators and as community members. The other thing is that I think this is symptomatic of a wound in our society that needs to be healed, and we need to work together very hard to solve that problem. And whether conscious or unconscious, it's a problem that is voiced by the words, "You don't belong here." And we really need to confront that and figure out how we are more inclusive, how we are not turning people away because they're different. And even if that's not necessarily the intent of those who might exclude or suspend students, that is the message that's perceived by other communities. And we need to make sure that we are speaking to that and that we understand how we can heal that wound. It's very important. Thank you.
And Representative Bly, I think those were excellent closing comments. Representative Kresha.
I'm going to leave it at this. And Representative Bly, thank you. I was actually going to, you're right where I was hoping we could be. Let's have the conversation. And you said something in there. You said there's the perception. Let's remove the perception. I'm listening, I'm not hearing, and there's a huge difference. And I think that, I'm sorry I'm born this color, I'm sorry of who I am, but that doesn't mean I won't listen.
Oh, excuse me, audience.
Excuse me, it doesn't mean I won't listen to the conversations and bring us to the table. I'm trying my very best just to get people to talk, and that's all I can do.
Thank you, Representative Kresha. And with that, the chair renews the motion that House File 905 be laid over for possible inclusion in an omnibus bill.
Thank you, Madam Chair.